I sort of first, in any fight, when you enter any fight, it is always good to know what your rights are. And only then can you effectively resist a fight, let alone settle it. So years back, this was in 2011, 2012, this strapping young woman entered the office. We had a conference with her. She had a sister. Unfortunately, her dad died all of a sudden, and this girl was hardly 27, 28, and I think the father was not even 60 when he passed away. I asked her, how many heirs did your father have? Because the father passed away in the middle of some negotiations. We were negotiating for the sale of an apartment that he owned, and then he passed away. And I'll never forget her answer. She looked straight at me, and this wonderfully confident MBA from a good college looked straight at me and said, "Oh, well, you know what? My father didn't have any heirs." So I looked straight at her and I said, "I can see an heir right across the table. So why do you say that?" And then her response was, "You see, well, my father didn't have any sons." So you can have n number of laws, but still, here we are talking about an independent lady who's an MBA. So women have equal rights as men, and all that nonsense about, oh, the brothers try to sort of yes, bully and outdo their sisters out of inheritance by saying that, oh, well, we gave her a grand wedding. She's married to a well-off guy. She doesn't need, whether you need it or not, whether you had a big fat Indian wedding. All women have a right in, if the father or the parents die intestate, the the daughters have been put on the same footing as men. And I'm talking about Hindu Succession Act. The other interesting thing that women most of the time don't realize is that since 2005, and in Maharashtra much prior to 2005, they have an equal interest even in the co-parsonary property, which means in the Hindu undivided family property. So, in fact, now the current thought process is that because they have been, put on the same footing as the boys, as the sons, they can even be kartas in a joint HUF property. The other aspect that I would like to highlight is, supposing, whether be it two sons, boy, son, daughter, whichever combination, cousins, and because, often in a large family business, cousins to have a stake. So when we're talking about family property, the other co-owners, have a right of what do you call it? Right of first refusal or preferential right. But this preferential right flows from the law. Co-owners in any property have a preferential right. So I think that was something important that everybody should know while, when they find themselves in a fight. Also, where as far as family property is concerned, if uh, supposing you have X has a family property, or let me take the name of somebody in the from the audience, so that I know that everybody's there, not just logged in. I see a name, Rahul. That's a nice name. Rahul, can you enable your video, please? It's the first. So let's suppose that Rahul has a family. Rahul's brother has a family property, or his sister has a family property in which he too has a stake. It's a property that he inherited from his, say, father. Now, Rahul cannot uh, just sell it to an outsider. And if it sells, firstly, the other siblings will have a right of first refusal. So he has to, under law, offer his stake to the other co-owners or the other inheritors. Now, suppose, let's take a situation where the other inheritors say, we don't have the money, or we can't match your price for whatever reason. um, Rahul is compelled to sell the property which is a family property, his stake in the family property to an outsider, a stranger. Now, can the stranger insist that he stays with the family? No, he cannot enter the property and start living with the family, which is already start living there. He has to file a suit for partition, and only then can he enjoy his share of the property. So the stranger or the outsider to whom the property has sold, he will have to go to the civil court, file a suit for partition, file a suit for partition by meets and bonds, and only then will he be able to enjoy the fruits of his purchase. So these are a couple of things that I just wanted to generally highlight. And then I would like to talk about documentation, because I'm personally of the opinion that just as good fences make good neighbors, good documentation ensures that the relations between family members are smooth. Now, how do you ensure? What is it I mean by good documentation? Time round the clock, we do a lot of uh, this purchase documents, agreements for sale, like deed of transfer and the like. And often properties are purchased by, very typical example, properties are usually purchased by the spouses in their joint names. Now, one aspect that people don't realize about purchasing property in joint names, residential properties are usually purchased by spouses in joint names, but as far as shops or commercial properties are concerned, now commercial properties typically are not, people don't invest in commercial properties with the intention of using them. Most of the time, people purchase commercial properties by way of investments. So often you have a situation where two brothers decided to pool in funds and purchase a gala, shop, warehouse, whatever. In such a case, we make it a point to write in the deed of transfer or the purchase document the proportions in which each brother shall owns the property. Here, I would like to highlight two concepts. One is tenants in common and joint tenants. Now, the word tenant is so misleading. So, can anybody tell me where I was? I would like to know who's logged in, who's genuinely logged in, and who's not. Oh, Raina. Hi, Raina. I see two, Raina and Manu, both known to me. Hi, Raina.
Hey, hi,
And
yeah, you were talking about joint tenants.
hmm. So people get in documents where the property is held by, say, two brothers or two individuals, not just spouses. We make it a point to state that the properties are held by the parties, by the purchasers as co-owners equally in the ratio, say 50-50, 70-30, whatever the ratio that may be decided by the parties. Now, tenants in common, the word tenant is a misnomer. What it really means is the property is held in severalty as against joint tenants. And again, the word tenant is a misnomer. What joint, when you say properties are held by, say, Raina and Divya. Supposing two of us get together and buy a nice office in, I don't know, which area do you like? Nariman Point, nice office in Nariman Point. And if I write
No, BKC, BKC.
BKC, okay, a nice office in BKC, in which case Raina, I, and Malvika, all three of us buy a nice office in BKC. Now, if I write joint tenants, that means should something happen to either one of us, then the survivors get to own the property. So that is joint tenants, jointly. Joint tenants means the property is held jointly and not in severalty. As against, now if I say Malvika, Raina, and Divya hold the office in BKC as co-owners or tenants in common, that means it- it is held in severalty. So each part can be severed off. So it's very important that you record this in the document. You can imagine what an impact it has on the other point I would like to highlight is when you say co owners and severalty, besides the fact that, so supposing anyone dies, supposing I die, then obviously Bapu will get my share of the property. That is tenant. So he will hold the property along with Raina and Malvika. Now, if the document is silent, then it is assumed that each person holds an equal share. So therefore, but I make it a point to write the ratios. So in this case, I would make it a point to write one third, one third, one third. So I hope, and that is one concept I wanted to everybody to get right. Yes, Manu, you have a question?
Yes, ma'am. Actually, the co-owner basically then means the equal amount of property will be shared, and the inseverability, the percentage may differ. You mean to say that?
No. So see, as I said, you can have n numbers of co-owners. In this the example that I have given is Malvika, Raina, and I can be co-owners in this office in BKC. It's not necessary that all of us have one third ratio. See, even if you look at the Transfer of Property Act, if the document is silent, sometimes they look at who has contributed how much towards the consideration. So now, instead of getting into all
Correct,
these
ma'am.
complications, the best thing to do is have it recorded in your deed, in your title document. That is your deed of transfer, your purchase deed. How who who has how much interest in the property. So this is a very simple example. Malvika, Raina, and Divya may not have one third, one third, one third. It is quite possible that Raina has contributed more. It's quite possible that Malvika has contributed more and that she has a greater stake. So that is another concept that I wanted to highlight, that
Correct, ma'am.
co-owners does not necessarily mean equal share. So so from there on, this is generally about rights and issues which can cause problems. And same goes for partnerships. You see, partnerships, right? People enter into partnerships because two brothers decide to do some business, and they come up with a deed of partnership. A partnership document should be so well drafted that it should be a code by itself. See, unlike a company, a partnership is not a separate, does not have a distinct identity. It's not a separate entity. So have it recorded in your partnership what will happen to the interest of any partner should any of the partners uh, decease or pass away, which is very important. You see, businesses go on. To establish goodwill, you take at least 5 to 6 years, sometimes 10 years. And a partner may, suddenly die 20 years later. It's everybody's effort that we are talking about over here. And as I said, in all these issues, you cannot have a stranger cannot be foisted on any family. A stranger cannot be foisted on any business. So you have to think through when you draft documentation. The other bit that I wanted to highlight is, you know, eventually, very good example was Mukesh Bhai and Anil when these brothers started sparring. I think brother sparring has been a very nice topic for movies, novels, you name it. Now, let me ask the audience this question. You think an MO is supposing two brothers are fighting, or there's a big family feud, and then everybody decides on who gets how much. So, will an MOU be sufficient? Will a letter be sufficient? Or there should be further documentation? Let me ask the audience this question. Yes, Manu.
Ma'am, I believe MOU will not be sufficient because the court might ask for other circumstantial evidence for the amount of share a person is holding or something, uh, something as such.
A very good answer. We are not on the same page as the reasoning, but you're not wide off the mark. But yes, that's an excellent hint. Can somebody else? So I know Reina and I know Manu, and I know that the two of them are actively participating in this webinar. But I would like to know what about others. Is there anybody else? I see quite a number of names here. Yes, Girish, can
Uh,
you enable?
basically, as the name indicates, Memorandum of understanding is just an understanding. It doesn't deem that there is a concurrence of mind. This is what I understand. So you can say it's almost like a half-baked document. Is it okay?
Excellent answer. You're a practicing advocate, sir?
Yes.
Yeah, you had so much authority in your speech. I was sure you're a practicing advocate.
Thank you.
So yes, that's right. MOU is a handshake. It does not mean anything. It's just a handshake. And as Mr. Girish said, it's a half-baked document. Also, I take the point that Manu made. It's just circumstantial evidence. It does not, an MOU does not vest or divest any interest. Today, for this webinar, I was having a quick look at the Hindu Succession Act. They have, in 2005, even the definition of partition was changed to state that partition means partition by a document registered under the Indian Registration Act 1908. You look at Section 17 of the Registration Act. What does Section 17 effectively mean? It means anything, whether you create an interest, whether you extinguish an interest, if something has to be done with respect to an immovable property as a fait accompli, then the document has to be registered. So, very often when we conduct title due diligence, the people forward to us letters, NOC. मेरे भाई की तो NOC है मेरे पास affidavit है. Even an affidavit is not going to, भाई की NOC है that he has relinquished and released his interest in the property unto me. That is not going to help. Even an affidavit is not going to help. Relinquishment can take place only by means of a registered document, in this case a release deed or a gift deed. And also this is my favorite, I've been talking about this all the time. Whenever you sit down to draft any advocate, sorry, sorry, please, Malvika, edit that. Whenever you sit down to draft any document, please, please, please look up the Stamp Act. Don't draft the document, structure the transaction, and look up the Stamp Act after putting in all that work. All these documents have serious stamp duty implications. Partition would be typically stamped at 2% of the market value. Gift deed would be stamped at 2% of the market value. Anything between 2% to, I think 4. But these are, these transactions have stamp duty implications. Of course, a lot of exemptions have been given. So if the gift is of an agricultural or a residential property, from father to son or father to daughter, so the Stamp Act has relevant exemptions. Then the stamp duty applicable is just 2%. Release deed, if X releases his share in ancestral property in favor of his brother or sister, but the property should be ancestral property, then the stamp duty payable is hardly a couple of ₹100. So as I said, but unless you have a document stamped and registered, it won't amount to amount to a settlement. It will be as good as any letter, as good as an oral statement. So that is all that I wanted to discuss. You can ask Bapoo about all types of fights. He has got excellent alimony in matrimonial matters. He has won matrimonial matters for husbands. You know how most husbands complain that the matrimonial laws are very one-sided. So yes, and you'll get a very balanced view. So, but thank you so much, and I'll be on the sidelines. Well, thank you.
Since we are talking of family feuds, uh, let me tell you that it's one of the dirtiest of legal matters. It's terrible it will even tell on your health if it goes out of hand. I know there's a bit of money in it which most people try to extract, knowing fully well that when there is a fight, people are always willing to throw money. Let's teach her a lesson, or let's teach that fellow a lesson. And even the families are willing to pull in a lot of money just to teach them a lesson. This is how they start. So, family feuds is not a very nice thing, but there are ways to handle this. And these are ways which you will never, no one will teach you that at college, nor will you be able to read that in books. If you, I mean, when I talk, I would naturally talk of personal experiences. The thing to do is to be calm. Whether it is the husband or the wife, when they come to you for the first time, they are always in a very nasty mood. Um, Let us look at it this way. They say that marriages are made in heaven, but divorces are in a boxing ring. It's everything goes okay with the marriage, and I've often seen that people talk of the spouses as if they are gods, and within 1 year there are problems. Maybe it's a matter of time before they adjust to each other, but often they don't. And the not necessarily the spouses, but their families very often try to make money out of it. Suppose I'm earning, say, 50,000 rupees a month. If my wife wants to file a divorce, and as Divya rightly said, the laws and even the courts are extremely women centric. I don't say that the judges wants to favor women, but the laws are framed in such a way. At one time, they might have been very well meaning laws trying to protect the woman. I'm all for it. In fact, I'm not, I'm for women being protected because they've been harassed and treated like chattel for years. But somehow or the other, things get out of hand and the husbands have to bear the brunt. And the worst part is family members come into play. I have known of many cases. Normally, it's the girl. The family uses this as an excuse to extract as much as possible. I'll go back to cases which I have handled. One of my very first cases in divorce, I was hardly a year or so into the profession. The wife had delivered a girl. Now, obviously, when the first child is a girl, the woman is not fit to be a wife anymore, and problems start. The That particular girl was totally illiterate. I mean, if you asked her to sign a piece of paper, she would do it in handwriting, which would vary every time. The husband wanted to divorce her and literally put her out on the street. The girl really didn't know what to do. There is this baby girl with her, and she had a policeman as her brother. Somehow or the other, now remember, they are living in a jhopatpatti. The fellow says that the husband says that he's some sort of estate broker. I don't know what that meant, but whatever it is, they just wanted to throw her out. Somehow or the other, I got the girl 8,000 rupees a month. Now, this was about 15, 20 years ago. For her, it would be a good amount to be able to live life comfortably along with the daughter. The next time I went to court and I told the judge that we haven't received any money, he said, Mr. Malcolm, it's not 8,000 rupees, it's 1,500 only. I said, how is that possible? He says, after you left the court, the husband and the wife came in here and settled for 1,500. Now I don't know whether the wife was coerced into it, or the fellow must have told her that, okay, let's forget everything, you can come back home, which would be the most And she would be the happiest person in the world at that time. And obviously, even that 1,500 rupees didn't come. We went through the motions, and alimony was fixed at 28,000 rupees, which for her was a fortune. It was put into a joint account with the brother, the policeman, and she didn't get a pie. The brother usurped everything. So what happens is invariably these fights start, and the family members are the biggest demons that you have to fight. So when a matter like this comes over, listen to the family members. Obviously, you can't stop listening to them, but take whatever they say with a pinch of salt. Now, these are not things that it is not something that any book or any college is going to teach you. This is far beyond that. You have to study psychology of the parents. You have to study psychology of the husband, the wife, and make sure that the child doesn't suffer. Most of them will say, I want the child. I will tell you, at not 50, 90%, at least 50% of the time, the persons who want the child don't really want the child. Nobody wants to take that responsibility. But if I were to say, I want the child, and the wife says, I want the child, the idea is to make sure that maintenance for the child is minimum. If I were to say, I don't want the child, let the wife take, then obviously the wife would ask for a good amount and I would have to pay for it. So here again, they use the child as a pawn. I'm telling you, this is this business is an extremely dirty business. But somehow or the other, you have to manage it. It can be managed. In fact, I'll go to another case. Husband and wife, obviously, after some time, couldn't see it eye to eye, and filed for divorce. We were for the husband. It was COVID time. And I've still not met the wife. I've never met her. But when we served papers on her, naturally, there was a lot of anger, which we as advocates have to listen to, because the husband and wife are not talking with each other, not talking to each other. So I had to bear the brunt, maybe an hour, 2 hours at a time. But by discussing the matter with both of them separately, we were able to solve the problem for literally tuppence. Literally tuppence. Both of them didn't see each other. They were just papers were exchanged and things were done. Last moments, everybody went to court, went out happy. So it's not that it's impossible, but each case has to be handled def- differently. And as I said, it's not in the books. There's nothing in the books which will teach you how to handle it. Time heals all wounds. So if you can, try to spread it out. Doesn't mean that you start charging the clients for every visit or because that, but try to spread it out. Because over a period of time, people come to realize that there's not much sense in fighting and they might as well go their own ways. As I said earlier, beware of the in laws. Most fights we find, the cause is the in laws. If you leave the couple alone for some time, everything gets sorted out. But the in-laws not only breathe down the opposite spouse's neck, they even breathe down our necks. There we come to another problem. Suppose there is a divorce, and sometimes it's better to get them apart rather than try to put them together. After some time, the problem will recur. If they can't get along, let them go. In fact, I was reading about maybe the biggest divorce in history, partition of India, where Sardar Patel and Nehru, who, in fact, Sardar Patel said this, that if two brothers are fighting, what's the sense of keeping them together? Let them go their own way. Uh, Otherwise, they'll keep on fighting indefinitely. The same thing, just this morning I was reading this, very fresh in my mind. So the thing is, if the spouses want to separate, sometimes it's better to let them separate. But at what cost? That is the crux. If suppose you are for the wife obviously she has to get money from the husband. Though there are laws which can be turned the other way around. If the wife has a lot of money and the husband doesn't, it can be turned the other way around. If you're a good advocate, you'll be able to do it. The wife has to get. Now, suppose the man is earning a lakh of rupees a month. There's a child. Usually there is only one or two children. If there are more, you'll very rarely come across a divorce with, unless the couple is 70 years or 80 years old, where the children themselves wonder why the hell they're going in for a divorce. But one or two, one child or two children, the question is quantum. Now let us take it as husband is earning 1 lakh of rupees a month. What should the wife get? Now there are decided cases. One of them is that she should be able to live in the same style as she was when divorce proceedings started. If they are living in a home with 2 bedrooms, obviously she would be entitled to a home with 1 bedroom, and she's got a child. Out of that lakh of rupees, 50,000, is it okay? No, I have to look after the child also. So maybe 60,000. The husband would say, no, I have my parents to look after. So what the courts do, and what I think is a very good idea, is to make out a balance sheet. What were you earning? How much were you spending over the last 3 or 4 years? If the marriage has lasted 3 or 4 years. And then the court takes a very judicial decision. Some courts may not. Now, there are cases, in fact, if you are on LinkedIn, there is a fellow called Amish Agrawal. He fights, obviously, he's got a lot of experience in divorce matters. I didn't even know that there were so many divorce matters as to go to one advocate. But if you are on LinkedIn, you can look him up. Almost every alternate day, he comes up with something to do with a divorce case. Now, if you ask me for something, if you ask me, Bapoo, how much money do you want? I will say, as I will want as much as possible. Why should I settle for anything less? So, with a fellow earning a lakh of rupees, the wife might ask for 10 crores. Goaded by her parents, ask for 10 crores, ask for 10 crores. And there is the feeling, which very unfortunate. People think that if we go to court and ask for 10 crores, we'll get 5. It's a very common feeling. There is sort of a bargain. Fortunately, of late, maybe for a year and a half, I have noticed that judges are not very happy with these sort of demands. I mean, it becomes a fish market. You start haggling. Somebody says 5, somebody says 4, somebody says 7. So whenever you are in this sort of a position and you have to make a demand, as I said, normally uh, on the uh, on the side of the wife, please be very sensible, because only then will you go ahead. Try to work it out sensibly, in the sense that what was the position at the time of divorce. Now, if you're for the husband, please don't try to cut corners and say the girl left me or whatever it is. I don't want to give her a thing. Why should she get anything? Let her get married with somebody else. That also does not work. You, in your own mind, have to be just also. You have to be fair to both sides. Even, and I'll tell you what, if you are just and fair, you will find that the other side is more amenable to reason than your own. We have had cases where the other side, being reasonable, our side has started to ask awkward questions, knowing fully well that the other side is now coming around. Why not? Why not put the screw on a little bit tighter or very much tighter? So here again, you have to. It's a matter of getting into the minds of people, sitting down, telling them what's right, what's not right. There are husbands who don't want to give anything. We are equally angry with those husbands. that no, you have a child or you have children. Please understand that it is your duty to give something. It's your it's your duty. Don't talk of rights, this, that, and the other. It's your duty. You have to look after the child. You have to look after the wife. There could be recently, since wives have started working, there are instances where the wife has been earning more than the husband. Now, if a wife is earning more than the husband and they split, again, four variations. Suppose don't have a child. Is the wife entitled to a very big amount? If you ask me personally, I would say no. If both of you are earning and the wife is earning more than the husband, why should she demand a very high price for a divorce just because she's a woman? I think it's unfair, and the laws, whatever they might be. So it's your duty to explain to the judge what this real situation is. As I said, make sure that the earning capacity of both spouses is put before the court. People being people, they will always try to hide things, prevaricate. Well, accountants know how to hide, how to manipulate accounts. Make sure that that does not happen, at least from your side. The other side, you can always trap, cross-examine, find out. But at least from your side, keep it very distinct, very clean. In which case, the judge will invariably take your side. So you have an instance where a wife is earning, say, twice as much as the husband. They divorce, no children. Why should the husband be put to inconvenience at all? If there is a child, then you decide how best to split it. If the husband, if there are two children, then obviously, and if two children go with the husband or the wife, whichever way they go, that person would naturally have a lot to spend and should get a larger amount. There was one case where the husband was prepared to give everything to the wife, including some 3 or 4 bedroom flat, etc., etc. He said, I just want to get out of it. Let her have everything. Yet the wife wanted more. Now, this fellow has a certain capacity. Obviously, just because he's been lenient, this is what I was talking about a few minutes back, that if the other side gives in, make sure that the screws are not put on. Now, this fellow just wanted to get out of everything. He says, let her take whatever she wants. Whatever I've got, let her take it. And it was a very dicey situation. I'd come in very late into that matter. By that time, it was really hot. Fortunately, I was able to explain to the wife that enough is enough, and now both of you go your own way. And every time this happens and a divorce is granted, I joke. I said, look, now that you people have got your divorce, promise me one thing. You'll never get married again. Because that's how it is. Now, I think I've laid the ground for questions to be asked. So will you please do that?
Sure, Mr. Malcolm. So, participants, now y'all can ask queries pertaining to inheritance, divorce, any form of property dispute.
Has any of the participants gone through a divorce? I was once before a judge who would spare uh, no chance to tell us that he had also already been through a divorce. Tell me, I'm listening. I think I've added enough grist to the mill for you
Yes.
to ask.
Okay. Good evening, sir. My name is Sumit Sawant.
Yes,
I
Mr.
have two questions for you regarding uh, inheritance of property, which is inherited from the forefathers. So, suppose a person A has inherited his property from his grandfather or father, and he says, "I am relinquishing my right in the property." But he has a son. Can the son, after attaining 18 years of age, say that my father has relinquished his right in the property, but not my right? That is my first question. And second question is, what, assuming all these are in this is a Hindu family, and if
Yes.
the son gets married according to the Marriage Act, then he will be governed under the Indian Succession Act. So what will be
Yes.
the position of the son with regards to the property in the ancestral, his ancestral, what will be the rights of the son in the ancestral property?
But are we talking of a divorce or are we talking of
No, no,
inheritance? Right. So
inheritance, sir.
you should have asked that question to Divya. We'll hold on. Then Divya will come back on that.
Okay,
Yeah.
sir. Okay, thank you.
Because it's a rather complicated question. And anyway, if you ask me what is right, I could give you some answer. But Divya is the expert on that, so let her do it. Otherwise, I'll have a family feud at
So
this evening.
the
Okay,
couple
sir.
of things. Your question regarding under which act everybody got married is a very relevant question, because if a Hindu gets married to a Hindu under Special Marriage Act, then nothing happens. I mean, it's not severance, it's not partition. But if a Hindu gets married to a non-Hindu under Special Marriage Act, and by Hindu I mean Sikhs, Buddhists, Jains, or any combination thereof, so it does not amount to severance. However, say if a Hindu marries a Christian under the Special Marriage Act, that would amount to partition, that to amount to severing the relations with the family. Now, you're talking about forefathers. We'll also have to look at the nature of the property, whether it is co-partnery property, self-acquired property, how the devolution has taken place, and which year.
Okay.
Moment on many scores. It was a landmark watershed moment, not only because women were given the same status, daughters were given same status as boys, sons, but also because survivorship was done away with. 2005, if the HU was continuing as on 2000, if partition had taken place before 2005 amendment would not be applicable. So this very concept of, great grandson and grandson automatically getting a share in co-partnership, it was done away with. The impact of 2005 on Hindu on co-partnership property really was putting it on more or less the same footing as self-acquired property. You know how an individual, you can write a will with respect to your undivided interest. So we'll have to look at the chronology, dates, and uh, need greater details.
Mr.
Okay.
Savant,
Yes, sir.
I have also learned quite a lot from your question.
Okay.
Divya has taught me. In fact, you won't believe it, but quite a number of these sessions teach,
Hmm.
teach me more than looking at books, because people ask such intricate and awkward questions. It really sets your mind going. Every session, I find that I know a little bit, know quite a bit more than when I started. Anyway, let's get back to family feuds. Anybody, is there anybody who has been through a divorce? Anybody listening in who has been through a divorce? I mean, it would be rather rare, but is it possible?
Any participant, and if yes, comfortable to share.
Good evening, sir. This is Swati from Mumbai.
Yes.
So, one of my friend's mother, she filed a maintenance case and she won also. For month 7,500 she got from the court order. But her husband didn't, he was the central government servant when the order was passed. And he didn't pay a single penny. And what he did after some years, he took a VRS. So he is not on a job now. He is a pensioner. So he didn't pay to my friend's mother. How she can go forward to get all the balance money from that years and also alimony from after he gets pension.
See, there have been cases like this. Um, the husband gives up the job and says, they say, if you haven't given up your job, go find yourself another job and pay.
Okay,
But
sir.
yes, that's it. It works that way. There are decided cases. A husband
Yes.
cannot give up his job and say, I'm penniless, so now I won't pay. Um, um, Very recently, I think about a month back, I read about a case like that where the court says we don't care if you don't have a job, you better work as a laborer, but pay her. This is what the court said. Work as a daily wage earner, pay her. So
But in this case, sir, actually nobody knows his whereabouts. He just gayab. He's nobody has his address. Even my friend's mother doesn't have address. Even the court doesn't have his address. So what can we do?
Get a detective.
There are so many ways in which a person can be traced. Now the police are not going to trace this person because they've got other things to do. But you could definitely appoint a detective to find out. It should not be very difficult. A man cannot disappear off the face of this earth. Maybe if he had a passport, if you know the passport number, maybe he might be abroad. Who knows? But you'll have to track him down. First, you track him down, and then move the. First of all, you make an application to the court saying that this fellow is not keeping his promise, and we cannot trace him. Maybe the court will give instructions. But in the meantime, I would sincerely suggest you appoint a, a detective and get going.
Thank you so much, sir. Thank you.
God you. Tell me what else.
Swati, ma'am.
Anything more, or is that all?
Can we unmute Kalpana, ma'am?
Good evening, sir. Am I audible?
Yes, absolutely.
Sir, I have a query regarding the distribution, as you said about the property. One client is there who it's an
You're an
ancestral
advocate.
property. Sir, I'm an
Are you an
advocate.
advocate?
Yes,
Yeah.
sir. So, sir,
I'll be
sorry.
charging you fees for this. If advocates
No
are
worries,
asking
no
me so
worries,
many
sir.
questions.
I'll forward the charge to the client as well, sir. So may I?
Tell me.
Sir, the client is no more now, and
Yes.
his son and daughter are there who had the property of their father. Now the son is also no more, and the daughter has already taken that the flat was given to the daughter. The daughter paid the amount, whatever was for the flat, to her father. So now it is not an ancestral property. The father got the money for that property. Now the son's son, that's the grandson of that
Yes.
father.
Old man.
Yeah, the old man. He says that as my father did not give an NOC for giving away that flat, now I have a share in the flat. So he is contesting for the same. So is that valid, sir?
Will you first tell me
Yes, sir.
who had paid for the flat? What is the certificate say?
Yes.
How was the flat transferred? Was it transferred after a probate, or was it just the secretary who had done it? Which, in my opinion, is totally incorrect. It's not only incorrect, it's illegal. So there's
Okay.
quite a number of things.
Yes,
Uh,
sir. So the first thing is, sir, the flat was given to the daughter. She paid the money,
no,
and it
when
was
you
not.
say given, please,
Yes, sir.
you're an advocate.
Yes, sir.
What do you mean by saying given? You can't give
Sorry.
a flat like you could give a pencil or a
Transferred.
pen.
Yes, sir. It was transferred to the daughter.
How?
Sir,
After the old
actually,
man.
the
Okay, now
flat was.
excuse me. Please
Yes,
start
sir.
from the beginning. The old man.
Yes. So
Old
the
man.
old man purchased a flat,
Yes.
and his daughter was staying in that flat.
Yes.
Okay, sir. Now, when the old man was on his deathbed, the daughter paid the money to the old man for the flat which in which she was staying, and she kind of purchased the flat from her father itself, so that the other siblings would not fight for the same.
Did she pay the full amount for the flat or only part of it?
No,
And
sir. She paid the entire amount.
the entire amount means was it valued? Was it really the entire amount? Was it half the? I mean,
Yes,
it
sir.
might be.
The present value of the flat she paid, what was the current value of at that time, not when the father purchased the flat.
If I were the judge and it goes to court, the first thing I will ask is
Yes, sir.
why did she pay the old man on his deathbed? He didn't need the money then.
No, because she thought later on there would be disputes among my siblings because there were 7
Fair
siblings.
enough. Fair enough. Let's go a little bit further.
Yes, sir.
Money is paid to the old man.
Yes, sir.
The daughter says, now I have bought it.
Sorry, sir.
Daughter says that I bought the flat.
Yes, sir. Yes, sir.
How was it transferred to her?
Was transferred to her, to the secretary, to the.
I mean, as an advocate,
No, Mr. Malcolm is asking as a gift deed, release deed, sale
no,
deed, will deed.
I understand what Malvika. I understand what the problem is. You go to
Not
Uh,
the
by the gift.
secretary, either he's your friend or you pay him something and he puts your name
No, no,
on
no,
the
no,
share
sir. It was
certificate
through.
for something or the other. That is totally
So it was through proper sale deed only. He sold like a sale deed. He gave it to his daughter.
no, not when you say like.
Hmm.
What do you mean by like of sale
I
deed?
mean, I mean,
Was there a sale?
yes, yes,
It was registered.
yes. It was a
There was a
registered sale deed.
registered sale.
Yes,
That makes the sale perfected. I mean, you
yes,
did
sir.
not tell me all this initially, so I was doubtful.
Yes, sir.
If she
Yes,
has
sir.
paid the amount to the old man was the who only person who owned the flat. Maybe he had his wife's name on it. I don't know. I
Hmm.
haven't seen the share certificate. Whether there was
Yes,
anybody else on where the son. It could be so many things.
yes,
Usually,
sir.
people don't buy the flat in one name; they buy it in two or three names.
Okay.
So when the daughter buys it, has she bought over her share? Has she bought over his share? Has she bought over her brother's share? All those things will have to be looked into. There can be so many
Okay.
permutations and combinations in these things. And
Okay.
what does the sale deed say? Does the sale deed indicate that he was the only owner?
Yes, yes. He was the only owner. The sale deed indicates that, sir.
That doesn't mean he was the only owner. You make up the
Okay.
sale deed. The daughter and the father make up a sale deed and give only the father's name. For all you know, there might be three other siblings whose names have been purposely excluded.
Okay. Yeah,
It can,
because there are other siblings as well, but the
yes,
others are not contesting, and there is one who's no more, and his son is contesting, like the
see,
second generation. Yeah. So he's saying my father didn't give an NOC, and it was all done
if it
among
doesn't
them.
contest, it is one thing. If it is not contested,
Hmm.
if you will look up limitation, contest can be at any given time. It, there's almost no limitation on that. 12 years, 20 years, you can do that. Now,
Okay.
don't say that they are not contesting. Their children might contest.
Yeah.
Never know. So,
Okay.
unless you see, there are so many things. First of all, you find out the original purchase deed. That means, how did their father, the old man, get hold
Okay,
of
sir.
the flat? How did he pay? How much did he pay? What does the original certificate say? You have to go step by step and then ensure that
Okay.
nobody else is in the picture.
Yes, sir.
Yeah, I mean, I wish he had made a will. If he has not made a will, see, the first thing the judge will ask is, why did you pay him on his deathbed? This is the first thing that the judge will ask, and he will start doubting it. That
Okay.
was he in his right senses when he sold it to you? When you
Okay.
got the sale deed registered, if he was in his deathbed, how did you get it registered? Did the register come home to do it? Did you take him to the register's office? Who were the witnesses? You, there'll be a lot of questions asked. And I agree
Okay, sir.
with the judge if he asks all these questions.
Got it, sir. Fine, sir.
Sorry.
Yes, yes. I'll go through each and every points minutely as you said, and then I'll suggest a plan.
Always in a case, I would suggest you be the devil's advocate. You
Yes,
think of
sir.
what other person wants to do, what the other person is thinking of doing.
Correct.
Put
Yes,
yourself
sir.
in their shoes. Only then will you come to a correct answer. And
Certainly, sir.
and remember that clients don't always tell you. If they may not lie, but they definitely don't tell you the whole truth. The nine times out of 10 this happens. Very rarely will you get a very honest client. You have to
Yes,
be
sir.
extremely careful. Clients can get you into trouble.
Sure, sir.
Hmm? So God bless.
Thank you so much, sir. Thank you so much, sir, for your valuable inputs. I'll surely get. Thank you.
Mr. Malcolm, the next question is, there is a woman who has been abused by her husband and is a victim of domestic violence. She has a 18-month-old daughter. After her marriage, she was not allowed to work. Now, her father in law doesn't want her to cohabit with her husband, wants them to separate. But at the same time, the husband and father are not willing to give her any maintenance. So, what are her rights in this scenario?
Normally, as I said, the courts are a little bit favorable to the women. Now, if what this lady has told us, and it's absolutely 10% true, she has no job, she has no house, all she's got is the burden of looking after a young child. Um, if okay, now, if I were the judge, what would I do? If I were the judge, very simply, I would put her into a place, into a position that she is in or was in before the trouble started. I would do that if I were the judge, and that is what she should also look for, a position that she was in. Don't ask for the moon because you're not going to get it, but ask for something. See, the thing is, don't try to make a profit out of this. This is not a business. So don't try to, as I said, in laws very often try to reap a very good harvest. In fact, sometimes I feel that they put a woman into a marriage with the intention of getting something out because if people fall apart within 4 months and 6 months. Uh, it's impossible to understand this. Second marriage, third marriage. There was a woman who had married some 5 or 6 times in Karnataka, and every time she was getting alimony. So we really don't know. You have to go very deep into this. But if I were the judge, the first thing I would do is make sure that the wife and the child are put into a position that they were in at the time of separation. This is what I would aim for. At least that I think no judge will deny. And whenever this sort of a thing comes up, very often the wife asks for, say, 10 rupees today, but 11 the next year or 12 the year after that because expenses for the child keep on increasing. Child might be 2 years old, fair enough. No schooling, no uniform, no books, no nothing. Later on, all these expenses come up. So you have to factor that in. Another thing is, I forgot to talk about it. Normally, when there's a problem, there's a family fight, and you go into a divorce, you are asked first to talk to a counselor. I have never seen it work. I don't know whether the counselors are trained enough or whether they are interested enough, but matters are too hot at that time for anybody to uh, give in. So the counselor, before the case starts, they say go to a counselor. I think that's not right. Uh, take some time, let things cool down, and let the advocates talk it over. So here again, if there's a divorce in the happening, uh, just take care. Things don't erupt overnight. No, I look upon it as a cricket match between India and Pakistan. Say there are 6 runs and the last over. The first ball, 1 run. Second and third ball is a dot. Fourth ball, it's a boundary. Now 2 balls and 1 run left. There's a wide, and people think it's not a wide, and there's a fight over it. You know, so things build up to a crescendo. It's very important that uh, if you see you are heading for trouble, try to nip it in the bud rather than wait for the last moment, hoping that it would settle down. Usually they don't. They just become worse. So if you are an advocate and somebody comes to you, hopefully comes to you before it reaches ahead, try and sort it out this way. They said you don't find all these things in a book, but when you as an advocate will come across these, each case will have to be handled in a different way. Anyway, next question.
There's a question. What is better, a gift deed or a transfer via release deed to avoid future disputes?
If you ask me, I don't know how Divya will answer it, but I believe as a gift deed, pay your taxes and get it over and done with. Very often people give a gift deed and then find that they want the thing back, which is not possible. But they say, mine gift, yeah, we gave it a gift. Why should we not get it back? So best thing is to gift it, register it, finish it off. That's the end of the matter. Don't keep anything hanging.
Another thing I would like to highlight is that you'll get advantage of the gift deed, uh, of release deed, only in case of ancestral property. So supposing you have inherited property from your dad, and you have a brother, sister, and one of these, often the children decide to relinquish their interest in favor of the mother. That too happens. Now here, each party has a stake, and therefore we call the document a release deed, not a gift deed. In a gift, it's not necessary that the donee too has an interest in the property. But as far as Stamp Act is concerned, a release deed is you'll get stamp duty advantage only if it's for ancestral properties. So if it's your own property that you're gifting to your brother, sister, mother, then it will be a you'll have to do a gift deed. You don't have an option.
If you will notice, normally in these things, women are at a disadvantage. There is no doubt about it. Even though the laws might be favorable to them, they're very often at a dis. And that is one of the main reasons why I'm very worried about his uh, common code. I have a feeling that the common code will take away rights from women. I'm very, very, very much worried about it. Whatever they have got now, they are unable to enforce. And if it is a statute, they'll be at a loss. Anyway, let us see when it happens and how it pans out. Come on, with the next question, please.
Can a property inherited from a father be treated as a self acquired property and be disposed of as per one's wish?
Inherited from the father. How many people
Yeah,
would
yeah.
inherit
So
it?
how
Only
did
one.
how did the father get the property? See,
Hmm.
after 2005, if it's a co-partnery property, you can will away your undivided share in a co-partnery property. So, as I said, 2005 was a watershed moment. We talk about not only in the context of daughters and sons being given equal rights, but also they have actually revolutionized the concept of co-partnery, no survivorship, whoever has an interest. If I have a property, see, we grew up thinking that if I, with a high sense of individualism, individual choice. So that is what now the impact of 2005 was. There's a Supreme Court judgment too, which says that upon partition, so if there's a partition, then suppose the father has got the property in partition of an HUF. The HUF does not seize that property which he got upon a partition. It will now be the HUF property of his smaller HUF.
Does that answer your question?
But it,
I hope the participant got the answer.
See, each case is highly individual. It's impossible to,
one size fits all.
yeah, one size does not fit all. Every case, but the simple thing is put yourself in the other person's shoes. That's the best way to deal with every case. Whenever somebody comes to us, the first thing we ask is, excuse me, first thing we ask is, what do you want at the end of the day? And we want an honest answer, not something out of the air. You don't ask for the moon. You want an honest answer. What do you want? As the last question was, the poor girl is out of home, not allowed not to see the child. But suppose she says that I want a house, not a palace, a simple house, and I want to look after the child and I want money to look after the child. We have had cases where the mother has bought iPhones, iPads, everything for the children and then asked the husband, the The divorce case is going on, and then ask the husband to pay for it. Dancing classes, judo classes, all sorts of things. And then she says you have to pay for it. Now, no court is going to allow that sort of thing to happen. All of a sudden, you want to spend on the children so that the husband has to pay. It works both ways. You have to be very careful, very honest in this matter, and it's a practical. That's about the only way you can sort matters out. Otherwise, these cases go on for years on end, and there is acrimony, there is bitterness. It's terrible. It will even tell on your health. Forget the two warring parties. I'll tell you. I'll tell you how it works. This is fantastic. You go to court and you are fighting a case for somebody. Either husband of the wife, it's immaterial. The other advocate is also fighting. Both the advocates are fighting tooth and nail. Each one wants something or the other. There's a lot of shouting, all sorts of things. Maybe the advocates don't even want to look at each other. Finally, in the afternoon, you go to the Chief Justice's court and he says, okay, Mr. and Mrs. A, you are divorced. Mr. and Mrs. B, you are divorced. C divorced, D divorced, whatever it is, the group. It says all of you are now divorced. You won't believe this. Quite a number of them start hugging and kissing in court. You start to wonder, why were we fighting so much and what is happening? So sometimes over a period of time, they realize that there was something wrong and things tend to smoothen themselves out. Don't rush into it. When it's hot, it's meaningless. You can't touch it, don't touch it. Anyway, next question.
So, would you advise consulting a private mediator?
Private mediator, there is a consultant available. The courts insist on a consultant. But I haven't been to many consultants actually, but I find they're not par for the course. Let me put it that way. Most of them are honorary. They don't really have time. Um, Now take the Parsi matrimonial court. It maybe means once in 6 months or once in 1 year. And the only jury system in the country. Only jury system. There's no other jury system except the Parsi matrimonial court. Now normally fights start between people who are in the late 20s, early 30s. That is the time when most most people file for divorce. The jury, of course, the jury is only in name. It is only meant to advise the judge. Its word is not final. The jury consists of people who are in their 80s. Now, how would people in their 80s really understand the situations of 30 and 40, 20 and 30-year-olds? So there also you have a problem. It's difficult to explain to people who are octogenarians exactly what has happened and what should be done to solve the matter. Fortunately, their word is not law. Their word is not the last word. The judge has to take the decision. But these sort of things happen. Each case, as I said, has to be handled differently, and there are no laws. There are no laws available. There are no books available on this. Hold on. Next question, please.
Can a husband transfer his self acquired slum property via will to one of his son without the permission of his wife?
Um, if I own something and my wife does not, and I want to give it to my son, and I will it to my son, obviously the wife has no right over it at all. Zero. It's his property. He wants to give it to my son. He can give it to his girlfriend also, or XYZ. He can give it to a trust. He can give it to the government itself, like they look after it. If it's your property and you will it away, that's it. Full stop. No one can stop you. It's yours. You can do what you want with it, except if you are a Muslim. But that's a very good thing that I like in Muslim law. You can't give away more than one third. The 2/3 has to go to your family members. What else?
Okay, Mr. Malcolm, I think, yeah, we don't have more questions.
I hope that
Participants, Any more questions? Okay, one more question. One
Tell me.
second. Any tips for bequeathing movable property?
What do you mean by tips? You can always tip. If I give you a tip, I'll say bequeath it to Bapoo Malcolm. That's the best tip I can think of. What is the tip that you want? I mean, it's definitely not a horse race. Tell me, what exactly do you mean by tip?
So maybe the person wants to ask what is the general practice for that lawyers advise for bequeathing movable property.
Movable property. Let us take a car, for instance. In your will, you can write that my Rolls Royce goes to my son and my bicycle goes to my daughter. You can do that. No one can argue with that.
Sometimes we put photographs
Yeah,
and then
jewelry.
then sorry.
नहीं, yeah.
Sometimes you annex photographs, as far as demat accounts are concerned. Make sure that your will is in sync with the nomination so that the transfer process too becomes simpler. So supposing you have two demat accounts, in one, you want securities in one demat account to go to your son and another to go to your daughter. So have it, you capture that in your will, but make sure that your nominations too are in accordance with your will. Then you what other what are the types of movable properties you have in mind? Jewelry, for example, you might as well have two lockers so that there are no fights, or you annex photographs.
Yeah, photographs is a very good thing for jewelry. So please annex photographs to your will so that see, otherwise it's something that cannot be broken up. You can't say that 50%, so break the jewelry in two pieces. You just can't do it. Uh, each piece of jewelry, you please mention that. Now, coins, expensive coins, stamps. Obviously, you can't tear up a stamp between two people or three people. So, each of these items, please specify that this must go to so and so, this must go to. Now, fortunately, you have, in fact, you can even videograph it. But to maintain a videographic record for a long time might be a little bit difficult because of deterioration. The best thing to do is to take photographs. Each photograph, say photograph A, so such and such a thing. Mention the type of jewelry, whether it's necklace, whether it's a ring, whether it's earrings, whatever it is, should go to my daughter or my daughter-in-law, whatever it is. Even my son. Why you can even give the jewelry to the son? He might sell it and make some money out of it. So be very specific. People tend to forget these things in the will, and that is what. Anyway, we are now getting into wills. We were into family feuds, so let's stick to that. Any other questions?
We are done with the queries.
So then, in that case, thank you very much, Malvika. Let's let's hope it's been an interesting session. We do get carried away by these things, but that's how it is.
Yeah.
In a way, I'm glad. In a way, I'm glad. There's no sense in a monologue. You never know whether the person who is listening to you is interested or not, whether they've gone away for coffee and you're talking all the time.
Hmm.
It's always better to, it's a question and answer session, I think is far better. And we also get to learn quite a bit because you ask the awkward question, and when we start thinking, how could that be solved if we were the advocates and this question came up? We are prepared for that the next time it happens.
Thanks to the both of you for being personally so patient and so calmly handling all the questions and addressing the queries for the past 2 hours, and also being so open to share, because I'll be honest, I contact a lot of advocates and they say that we don't want to share the tricks of the trade. So
Come now. Malvika, you, you are going a little bit to the extreme. There is no lawyer who does not like to talk.
no, I do contact, and then they say that no, we don't want to share the what we do, because then we might lose business or the clients won't come to us. So
Because
yes.
impossible. That's not. It's impossible. It cannot happen. It cannot happen.
Yeah.
You talk to people, people know what you are doing, they'll come to you. You can't hide behind a screen and pretend that you're, uh, pe-
So both the Malcolms believe that if people get to know what we do, they might have greater confidence in us. So
and
I
in
think,
other lawyers also.
and so I think it's also different perspective. But Malvika, I need to really thank you for putting so much faith in us and giving us such uh, opportunities,
Chance to talk.
chance to talk.
We are very
Had
good.
a great time. I mean, time just flies in your session. I just don't know where time flies. So thank you so much for sharing your expertise and your experiences. Thank you.
See
Thank
you.
you. Bye bye.
Bye bye.
Bye. Bye.